right, today we're joined by Jeffrey Fidelman, CEO and founder of Fidelman Company, an investment banking and fundraising advisory firm supporting early to mid-stage startups and emerging fund managers. Jeff has spent his career at the intersection of investment banking, venture capital, and company building, including roles at Morgan Stanley, HSBC, early stage VC firms, and as an interim CFO and COO for companies navigating fundraising, acquisitions, and strategic transactions. Through Fidelman Company, Jeff and his team help founders think strategically about capital, not just how to raise it, but how to build businesses that are truly investable. That includes investor narrative, financial modeling, diligence preparation, and what he refers to as fundraise as a service, acting as an embedded extension of founder teams throughout the raise. In this episode, we're breaking down what deal ready really means, why most founders misunderstand it, how legal and capital strategy need to work together long before fundraising begins, and how preparation can dramatically compress timelines, protect valuation, and reduce deal risk. Jeff, thanks for being here. It's great to have you with us.
Thank you for having me, Brian.
So why don't we start with just having you provide an introduction on who you are, what you do, what Fidelman Company does. We'd love to hear your background.
Sure. Appreciate you having me on. I'm born and raised in the Northeast in Long Island. I ended up graduating from Harvard and spending, like many others with me, graduating class, the next close to 10 years in banking. And half of that I spent at Morgan Stanley. I was a PM there and ran a syndicate group. And then I was recruited to HSBC initially to do the same thing, and then ultimately ran strategy for them. While I was there, I was also then recruited by a family office that was looking to build a venture fund. We were a single family office investing out of a $125 million vehicle. I was a partner there, and our focus was mainly tech and tech-enabled companies. And the office had a really interesting strategy where we would anchor, kind of act as a seed or pre-seed investor as an anchor, or as a lead investor, and then help the founders syndicate the rest of the capital, go out and raise more money. And that's kind of where I recognized that the institutional structure that I'd been so accustomed to was or could be applied to early stage companies, to emerging managers, but wasn't. So I left the VC 15 and started what is now an investment bank. And over the past 10 years, we've grown to about 40 people, all remote, all US and Canadian based. And our focus remains on early stage companies and emerging managers, where you mentioned earlier, we run a process, we call it Fundraise as a Service. And the whole idea was to bring kind of this institutional mentality around how to raise capital in a structured, consistent format and build it as a managed service that we can provide to our clients who are these early stage companies or fund managers. And really what that looks like is that we went out and effectively created a managed service around best practices. So we subscribe to PitchBook and Preqin and Fintrix and ZoomInfo and Dakota and all these different platforms. We've aggregated all that data internally, and then we layer an analyst on top of it to do all the outreach on behalf of our clients. So Alex calls from ABC company, or Alex emails from abc.com, so that from the investor's perspective, it's the company or fund reaching out to them directly. So that's really what it is. We've built fundraising infrastructure and then effectively rent that to our clients on a month-to-month basis.
Yeah. And we've talked in the past that there's just a lot of philosophical overlap between Ivory Law Group and Fidelman Company. You know, we try to be that in-house counsel as a service, legal department as a service. You know, from my experience at a Fortune 500 company, how a legal department operates, taking those best practices and trying to make them accessible and available to companies that are earlier stage, don't need kind of the full suite of an in-house legal department. I thought it was a good idea to start Ivory Law Group. I think it's a great idea to have Fidelman Company going and to take those best practices and make them available to a different cohort. So let's start by talking a little bit about why deal ready is so often misunderstood. So we'll talk a little bit about being pitch ready versus deal ready, maybe some founder misconceptions, why readiness is about infrastructure, not just decks. But I'd like to start with when a question about when founders say we're ready to raise, what do they usually mean? And what do investors and bankers mean instead?
Founders being ready to raise is a philosophical, I am ready. I don't have enough money to buy the things I want to buy. And I don't mean that facetiously. Maybe it's software subscriptions, maybe it's hardware, maybe it's technology, maybe it's building it. I can't pay for what I want to pay for, or I want for my process and my build to move faster. That's kind of the initial inklings of an individual, of a founder, saying that I need to raise money now. And we'll talk about companies, right? Because fund managers are in a perpetual fundraising mode. So for a company, being ready to raise capital is really, again, more philosophical, more qualitative around, hey, I need money in order to do the things that I want to do, to execute on what I want to do. From a banker's perspective, or even an investor's perspective, there's a lot more qualitative need from them, right? So it's not just, oh, you're ready because you need more money to pay for stuff, but what are you going to pay for? How are you allocating that capital? What return on investment do you anticipate in spending, this money? You're hiring an engineer for $200,000. There's still a return on that. What is that engineer going to produce and going to do for you? So it's not just about asking, hey, I know I need money and I know I need to build kind of these general features, into being kind of actually ready to go out and raise capital, to have an explanation of where this money is going and how you're going to be using it and what benefit this money is going to give you. And I think there's a fine line between the two. I'm the last person to overcomplicate the documents needed for a raise or the amount of preparedness needed for a raise. But there is kind of a minimum line where you need to know your business inside and out, which many, I don't want to say all, but most even founders do. But when it comes time to putting that on paper and formalizing it in a commonly understood language amongst bankers and investors, that's usually where there's a little bit of a disconnect.
So can you provide maybe a high-level overview of the process you follow with the companies that you help raise, in terms of helping them identify, maybe where do you start helping them identify the messaging that they need to craft for investors? And I imagine that the process of crafting that message really pushes the founders to get to know their business and maybe identify gaps where they may be have softer knowledge than they need to when it's time to go approach investors.
Big time, and you nailed it. Right. So there's kind of two pieces of a fundraise or it's fundraise preparation and then execution, right? Execution is when you're actually going out and you have a process around how you're reaching out to investors, the methodologies, conversations, all of that. And then there's the process that comes before that, which what we're talking about, the fundraise preparation. And I've been doing this for over 10 years, kind of 10 years as this investment bank, and then even before that in working with founders. And it's so incredibly important to work in a collaborative manner. And for the founders out there listening to it, please don't go to some pitch deck consultant and say, here's my information, come back to me in a month with a fully designed and done deck, because that's only going to harm you in the long run. Same thing with a financial model. It doesn't matter that you can't write well, that you can't design well, that you can't do formulas in Excel. That's not what's important in either way, and that can be farmed out. But the fundamental narrative on what you're trying to explain in the deck and what you're trying to illustrate in a financial model are so important for the founder, the one who's representing their business, to know backwards and forwards. Mm-hmm. Even from our perspective, what we found works is working with the founder on the narrative. Pitch me your business. Let's go through an existing slide deck or a draft slide deck, slide by slide. What are you trying to accomplish and achieve? And of course, I mean, we give feedback on our thoughts and our philosophy as bankers on what should be on the pages, but really go through that iteration first. And then I always tell clients that the first kind of draft that we'll produce back to them, if we're helping them prepare for a fundraise, I call it draft 0.5. And what I want the founder to do is either absolutely love what's there or absolutely hate it. And I'd almost rather the latter. I want you to tear this apart. This is the worst thing you've ever read. Give me the harshest feedback, because at the very least, when somebody does that, you know that they're passionate about what they're reading and what they're looking at. No, this is wrong. Here's how it actually should work. I'd rather that response. And I try to elicit that type of response. People think that's kind of like wild when I tell them before they go through the process, and then they go through it. And all of a sudden, Brian, to your point, like they sit back and say, oh my gosh, like I never thought about my business in that.
Right.
So having someone play devil's advocate through the process is way more helpful than having someone sit there and say, I agree. Let me just write this in a more eloquent manner.
Yeah. Yeah. So what do you think some of the biggest misconceptions founders have about fundraising readiness?
I would say one of two, let's say, biggest misconceptions: timing around fundraising and the materials needed or the content needed to fundraise. And I'll talk about that maybe in reverse order. So the content needed, I always tell people that if you want to go out to raise capital, you need 3 items to start: a deck, a model, and a ask, a valuation analysis or an ask to understand like how much money you're asking for, what's the consideration that you're giving up for that. And all of those 3 documents do not need to be incredibly complicated. Like, don't do a 40-page deck. And if you do, don't share that yet. Just pare it down to like 15, 20 slides. The deck is not supposed to answer every single question. You are. The deck is really meant to support your narrative that you've provided and or act as a sales tool to get you to the next conversation, to the next step. Financial model should not be 42 tabs that each have variables or assumptions on, right? Like, have a tab with all of your assumptions, have a tab of all of your cash flows so that you can walk an investor through and say, look, here are my assumptions. If you agree with them, here's the result that they're going to produce. So, KISS methodology, keep it simple, right? I'm a big believer in that. And I think the misconception is I need my deck to answer every single question. I need my financial model to, again, take this with a grain of salt based on the stage of company, but I need my financial model to be the most complicated thing in the world that not even I can unwind. Like, these are not good things. It doesn't need to be more complicated in order to communicate to the investor, this is a viable business. As long as these relatively conservative or even aggressive metrics are met, here's the result, and we will be making money together. So I think that's one of the first misconceptions. More is not better. Less is sometimes better, just to get the sales process going. Yeah. And then timing, right? People still continue to ask, what is our diligence methodology of working with clients? And I used to joke and say, like, as long as the check clears, so does my diligence. But the reality is that when clients come in with, this preconceived notion of, hey, I need $5 million, you can get it from me in 30 or 60 days, right? Those are the clients that we proactively turn down, because every founder going into it, and there's always going to be outliers, but every founder going into it really needs to give themselves 6 to 9 months to raise capital. They'll certainly know what the market looks like within 2 or 3 months, with or without us, but really kind of on average, 6 to 9 months is what they need to prepare themselves to raise capital.
That's it sounds like a commitment and a partnership that you form with your clients. And imagine the relationship aspect to that is paramount, as it takes a lot of back and forth and conversing with your clients to make sure that you're part of their team. You're the messaging that you craft is as much of messaging they would craft, but with the expertise that you bring to the table about what do investors want to hear. In the next segment, I want to talk about where fundraisers break. So where there may be legal misalignment, cap table complexity, contract chaos, diligence surprises. What are the most common hidden issues that stall or derail fundraisers in your experience?
Well, the first I would say is maybe more common sense. If you're worried about something, then deal with it as quickly as possible, because it will come up in diligence. And I know that's a very blanket statement, and that's probably can be applied to all of life, not just diligence with investors on an early stage company. But if there's something that's keeping you up at night and stressing out and thinking that, like, I hope they miss it, if you're thinking that in any respect, get in front of it and don't hope that they miss it. They won't miss it. They will unlikely miss it. So that's number one. I know, very meta, but getting a little bit more granular is execution. Execution is why, or lack of execution is why most fundraisers fail. It's not about, hey, I got a list and I can personalize and reach out. It's about how often and how many times can you do that? How consistent can you be on the outreach, right? Raising capital is no different than sales. And sales 101 will dictate that in order to complete a sale, it's going to take a minimum of 5 touch points, right? So you reach out to the investor over email, maybe they respond, maybe not. Then you call them, find they respond. Then you have your first meeting with them, you give their pitch. Then you maybe have a follow-up, hopefully you do that. Then you have to send them an email every month as a periodic investor update to keep them engaged and keep them in the loop. That alone is already about 5 or 6 touch points if you're getting all of those touch points in. Not to mention that you need to now send a few months updates so that the investor sees that you're not sitting on your hands waiting for money, but you're progressing the business any way that you can.
Yeah.
So, the second, I guess, piece there is consistent execution, or the lack of consistent execution is why oftentimes founders or fund managers fail to raise capital. You're never going to get, never. I don't want to use an absolute, but it's highly unlikely that you're going to get capital from the first person that you speak to and raise capital. So, the same applies to the second, to the third, to the fourth. And what's funny is that by the time you're in it for 2 or 3 months, now you've already touched base with those initial investors, half a dozen times.
So where does legal complexity most often catch founders off guard?
Yes. So corporate organization, like kind of domicile of the business, oftentimes, people won't look into it too much. It's not that big of a deal, but we often see deals when they come to term sheet or actually funding that investors will want to re-register the business in Delaware, for example, or in some other tax advantage state. That's not necessarily something that can be done, but I would say to the effect possible, it's always a good idea before signing a document, including corporate organization documents or tax documents or term sheets or anything. It's anytime you need to sign your name on something, talk to a lawyer. Because it's one of those things where, like, measure twice and cut once. Most people are not attorneys who are kind of versed in what could go wrong. And that's really what you're paying for. It's an insurance policy against what could go wrong. You pay a few $100s to an attorney or however much to review a document. And that way you at least have this insurance policy, so to speak, of like, okay, I had a professional review this. A lot of times it's cap table and conversions as well, kind of spanning between finance and legal, where founders they're aware, but they're not fully aware of what the math actually looks like when they've raised a convertible note. Then they're raising a priced round where the convertible note will go through the conversion. And then a few times I've seen founders take a step back and say, holy smokes, I thought I was going to end up with more than 30% equity after all of these conversions happened. And it's only round 2. Mm-hmm. So I think that's something to be really acutely aware of, both while you're raising your early rounds in the form of notes, but also certainly prior to conversion, to make sure that you speak with a professional to understand what is the math around the conversions, but also what are your rights. We're working on a deal right now where bootstrap company, there's one investor that's signing a term sheet interested in coming in. The existing founders all have common shares, and the new investors coming in and taking preferred. And along with these preferred shares are a number of rights that the investor has: board rights, hiring, firing rights, different types of acknowledgments that they need to have. And it's so incredibly important prior to that term sheet even being signed for an attorney to review that and also explain to the founders on a line by line basis, what are the implications? And let's talk about worst case scenario. And I think that's one of the biggest benefits of having an attorney kind of on your side and going through any of these processes, is that you're always going to want to think the best case scenario. Fine. You pay a lawyer to think about worst case scenarios and protect you from those things actually becoming realities.
Yeah. Yeah. And I think if you find the right legal partner, it doesn't have to be overly complicated. Every time you reach out to a lawyer, there doesn't have to be a markup produced, right? There can just be a review and another perspective from someone with a particular skill set that, as a business person, you may not have. I think that some of the best advisors I've seen out there from a legal perspective don't overcomplicate, but look to provide a perspective that their client may not already have. Where do you think CFOs, general counsels, and fundraising advisors need to work more closely?
I think they need to, yes. I think they do need to work more closely. I think it's something you actually said at the beginning of this podcast around the application of both what you do and what I do, right? And 5 years ago, 7 years ago, 10 years ago, we kind of had this like marketplace economy start to come up, and all these fractional people, fractional executives, legal, finance, accounting, whatever, right? Like fractional people, third-party service providers. And over the past couple of years, a lot of these service providers, many of the service providers, had an option of, do I create my own firm or do I create a marketplace? Some kind of created this 2-3 lines removed marketplaces where they were getting business through marketplaces, created their own to push it out. And then others created their own practices around it, providing third-party solutions. And I think with what you're doing at Ivory, with what I'm doing at Fidelman, is kind of a play on these firms that we own, but not by providing third-party service, but rather by positioning that as becoming an extension of our clients. And I think that there's such a nuanced definition there, but it's so powerful to come into a room and knowing that my client knows I'm on their side. I'm not just like a banker getting paid and wanting to push across some sort of deal because I know the investor so well, right? And that's the opposite of what we wanted to build with our firm, where I can walk into negotiation and my client wants to sit next to me, not put me in the middle of the table because I'm not mediating. I'm negotiating along with my client, or I'm trying to get this funded with my client, right? From a legal side, you're not just trying to get a transaction done because you're getting a transaction fee and you can just tack on the hours. You're sitting next to your client and really being an extension of their company and their interests. So I think first and foremost, it's important to understand who you're working with. Is this a third-party service provider that doesn't really care so much? They just want to bill the hours and get it over with? Or is this someone that, like you, like me, actually become extensions of our clients and care? And I think if possible, right, for anyone listening out there, go with the latter, go with the people who are becoming extensions of your firm, because incentives are aligned in that sense as well.
Yeah.
And when that happens, then you are working as a team. Then there's a very, very, very thin line between, hey, I'm going to hire, Brian as my in-house counsel or Jeffrey as my in-house IR representative. We still have our own firms and companies, but we're all working kind of towards a common goal as part of the same team, as part of the same client. Yeah. And in those cases, the collaboration is huge, right? Like if I'm negotiating on a term sheet or on a deal, having you right there, kind of part of the company and being able to have direct communication is going to, first of all, it's going to help the company in the long run because our incentives are aligned and they don't need to worry about that, meaning like mine and yours along with the company. And number two, just efficiency, right? Like you negotiate larger deals or even call it a $10 million deal. You hire an attorney's office, like a proper, New York City or wherever city law firm. And, every term sheet turn is, $1,500 plus and 24 to 36 hours later. And look, there's certainly benefit to that, especially in larger deals and $100 million deals. I'm sure I'd probably still say like, let's go to a large firm and have kind of internal counsel. But for early stage companies or even emerging managers, the collaboration is incredibly important just for efficiencies.
Yeah, absolutely. I mean, the things that come to mind for me in this post-pandemic world where remote work and remote collaboration is so much easier today. It's become much more achievable to have this extension of your business from a third party where you don't need to be down the hall from each other. There are tools through Slack or Teams where you can very much integrate with each other's businesses in a very real way. That makes more achievable today than maybe ever before. And then second, to the extent that we can integrate with our clients' businesses, it allows us to do our job better. I'm a better attorney if I know the ins and outs of the business, and if I develop that trust and relationship with our client, it enables us at Ivory to provide a better service. And when there is more of a disconnect, like you traditionally see at a large law firm or perhaps companies in your space as well, I think the quality of service can take a hit if there's not that extension of the business relationship that you have. So what role can fractional CFOs and fractional general counsels, what role can those models play in creating leverage throughout the fundraising process?
Well, two perspectives really on that, right? A service provider at the end of the day is a service provider is a service provider. So hiring an attorney or another one, right? If all things remain equal, costs, location, regulatory compliance, all that stuff, then you want to go with someone who, number one, can add additional value, right? Non-compensated value. Do they have an investor network? Do they have a nice smile and I just enjoy talking to them more than somebody else, right? Anything that you can latch onto, know that you are in control of hiring a service provider, and there are many of them out there, and you need to make the decision best for your business. So when we think about what role can Well, first of all, from our perspective, it's really just around like managing the fundraise, right? As an interim CFO or COO or CSO or CIO or whatever, the acronym is less important to me. More so, the clients just need assistance and advisory and being a little bit more hands-on and helping their raise. Same thing from a legal perspective, right? Like, especially acting in the capacity that Ivory probably acts, all of a sudden there's network effects. All of a sudden, like, I've seen XYZ deals happen, and here's what to look out for, whether it's with a specific investor or just the legal language inside of the documentation. So I think also, like, you wouldn't hire a patent attorney to help you close on an investment deal, right? Same thing, with CFOs. I generally find that CFOs kind of have two tracks. The unicorn is one that's gone through both, but two tracks, one that went into like deep into finance, accounting, and tax and regulatory work. And then the other one, which is a little bit more like growth oriented, fundraising oriented, not day-to-day type of management. I probably fall into kind of the second piece of it because I'm not a CPA, I have not done bookkeeping. And most clients will bring me on in that capacity to help them with their raises. And I think that's kind of at least what my experience has been in being brought on specifically with the intent of helping with a fundraise.
So how does, to round this out, I'd like to talk a little bit about how preparation can change the outcomes within the fundraising process. Talk about things like speed through the process and protecting valuation, investor confidence, negotiation leverage. How does deal readiness, how can it compress fundraising timelines and make the company in a better position when it comes time to communicate with investors?
Well, again, I'll put it this way, and perhaps I'm a bit jaded because I've been doing this so long. So I think a lot about fundraising is common sense when asked in that way a question, right? Like, if you have two companies and they're the same type of business, maybe they're the same type of revenue, they're the same stage, they're the same performance, and you meet with two founders, and one founder doesn't know their numbers, is kind of like, I don't know what this money gets us for, and just unprepared, versus the one who's super sharp and like, here are my KPIs, I'm raising $4 million, it'll get us through 18 months worth of operations, we expect to achieve 1,000 clients within that time, and XYZ. Even though they're the same, being prepared, being that kind of like on point going into an investor meeting will compress the time to raise, right? Because the investor will walk away. I'm sure anyone who's either been in their own business and had a client or representing another client in some sort of capacity, regardless of what they were doing, when you have someone in front of you that you walk away saying like, oh man, she or he was on point, you're way more likely to listen more closely. If you're an investor, you're way more likely to double, triple, quadruple review that deck or that individual opportunity because you were impressed by how sharp this individual was. So being prepared, first impressions leave a lasting impression. I mean, all that stuff is very, very true.
What role does preparation play in protecting company valuation?
Well, look, company valuation at the end of the day is a negotiation. Mm-hmm. So be prepared to go into negotiation using negotiation 101, right? First, have your data backed up. Why are you worth $50 million? Tell me why, right? Like, the reality is that I've never seen an investor walk away from a company based on valuation. Now, if you have valuation that's like, I'm worth $1 million and I'm asking for $1 billion valuation, then yes, an investor will walk away. But by and large, if you have a good business and the investor thinks that you have a good business, they'll come back and say, you know what, you're not worth 20, I'll give you $15 million valuation, something like that. Mm-hmm. But being able to back it up, right? Why are you worth what you're saying you're worth? And then also, like in any negotiation, the person with the most leverage in a negotiation is the one willing to walk away. And, I understand very much so from existing clients, from past clients, I'm sure for future clients, it's, situations turn desperate after a while, but it's like, sharks can smell blood in the water. This has the opposite effect where every shark swims away when they smell blood in the water, not swim towards you. So, having confidence and having the ability to say, no, like I'm not going to accept those terms. And if it loses the deal, then it loses the deal. Look, sometimes that does happen. So be prepared for that to happen. But again, nothing I'm saying right now hasn't been written for the past 2, 3, 4 centuries of saying anytime in a negotiation, the one who is ready to walk away is usually the one that gets closer to what they want.
Yeah. Yeah. Well, Jeff, this has been a great conversation. I really appreciate you sharing practical execution focused perspective, what deal readiness looks like. Not as theory, but as lived experience, across hundreds of transactions. Thank you for taking the time. It was great to have you here, and we'll certainly be in touch, and we'll let our listeners know how to reach you if they have any questions for you outside of the episode. And thanks again for being here.
Thank you, Brian, for having me.